Okay, do apologize that we have been postponed for about 15 minutes due to the fact that we are confronting with some IT problem which may arise from the trade war between US and China, because the software we are using to hold this webinar is Zoom. Zoom is run by an American company, and their service in China may be restricted from time to time. So we do apologize. Now we have worked out a solution to the problems. Now the cable, the connection is quite good. And now we have two speakers. We have three. Two of them, David and Nevil, have logged in. So we can have a start. And then the first speaker, Mr. Ian Gaunt, when he logs in, then we will treat him as the last speaker. Then he will, as the past president of LMAA, will make the closing speech. So that's an okay arrangement. We do beg your pardon for the 15 minutes late. Then today, the last of the three webinars run by the co-efforts of LMAA and SFU. Then today we'll have two speakers, Ian Gaunt, David, then Nevil, Phillips. Then today's first speaker has been changed to David Martin Clark. David has long been a full-time arbitrator of LMAA. David has a wonderful, perfect experience in dealing with the substantive and the procedural matters in London LMAA and other arbitration cases. Then today, David will give us or share with us his experience concerning the preliminary issue, which is by far means a very important issue, which you may, the users of LMAA arbitration, may face or may have in their arbitral proceedings. Then let's welcome David to open today's webinar to give us his speech on the preliminary issues. David.
John, thank you very much for that introduction. Can I just check audibility? Can you hear me by raising your hands? Fine, thank you. I'm now going to share my screen with everybody. Because my presentation is on my computer. And the screen I want to share is here. And I'm going to try and run a slideshow so that I can have the benefit of some animations. Right. Well, as John said, I'm going to give us a quick overview this morning on the question of preliminary issues. But before doing so, and adding to John's apologies, I would like to greet our participants, firstly by saying good day in my native tongue, but then by saying also Ni Man Hao in my very elementary Mandarin. Let us begin then at the beginning and try and determine first what a preliminary issue is. Some of you will already know the answer to this question, but for others of you, it may still be a little bit of a mystery. The best definition that I could find of a preliminary issue is this one, which came from the lexology.com website. There you have it. A discrete or standalone element that, if decided, has the potential to conclude the claim or otherwise substantially cut down on the scope and costs of the litigation. And as John mentioned, to decide a preliminary issue can be, in appropriate cases, a very effective way of saving both time and money. So we're dealing here with an issue of procedure which leads us, if all goes well, to a partial award. The way a preliminary issue is decided is by means of taking advantage of Section 47 of the Act, the text of which I'll give you, but won't speak to. I'll just give you a moment or so in which to read it. In the next few slides, I want to examine with you typical types of preliminary issues that might be decided by a partial and interim award. Let's take first of all points of law. Now, within arbitration, points of law can, of course, be determined by the tribunal, but there's also a facility under the Act for the points of law to be submitted directly to the High Court for decision. I don't intend to deal with any further with the High Court's powers under the Act, because what I suggest we do is look at what I have called a tiered dispute resolution clause and see how that can give rise to preliminary issues which could be well decided by a partial award. Now, a tiered dispute resolution clause, what do I mean by that? Let me give you an example of one. You will see that the clause provides for some preliminaries to the commencement of arbitration proceedings. It's the sort of clause that's very appropriate for long-term contracts and also between Asian parties who culturally prefer to resolve disputes in a consensual fashion rather than an adversarial one. But such a clause can give rise to a number of issues, and I want to look at a couple. The first question under English law would be whether such a clause is legally enforceable at all, or is it simply too vague to have contractual effect? And that would be a question of law. But if the clause is legally enforceable, then you have the issue of whether or not the claimant has actually complied with it, has gone through those preliminary steps before issuing a notice of arbitration. And that, in fact, is a question of fact. But the point of my slide is that both of these questions could be answered by means of a partial award on a preliminary issue. Another example, questions of jurisdiction, such as, has the correct party been sued, and, or has the notice of arbitration been served on the correct party? these are, in fact, both of them, current questions in my own arbitration practice. I've been involved in awards on preliminary issues on both these points within the past 3 months. Sometimes in an arbitration, there is one or maybe 2 clauses which, how can I say, contain the solution really to the dispute. And rather than have a full-scale arbitration with witness statements and expert evidence or whatever it may be, it can sometimes be a very good idea to take this one issue of contract interpretation as a preliminary issue, because the decision on that clause is effectively going to determine the arbitration itself. What about questions of fact? Can they be well determined by a preliminary, as a preliminary issue? Well, yes, they can. If they would be, if the particular question would be decisive to the outcome of the case. Now, for example, is the claim time barred? A question of fact, because the claim was actually made too late, or because the required documents were not submitted in time. This is an issue that arises very often in the context of demurrage time bar clauses, on which we're going to hear in the next presentation from Nevil Phillips. My last example of a preliminary issue would be the issue of liability. By which I mean, let's take liability first and leave all issues of quantum or the amount of the claim to be decided later. I think we can all imagine cases where it would save a great deal in time and cost if we could decide the issue of liability first and leave over the question of amounts, not least because once liability has been decided, my experience is that the parties very often can sort out, can agree the numbers, the quantum of the claim between themselves without the help of the tribunal. Up to now, we have looked at some examples of where preliminary issues are going to work well as a case management tool in arbitration. So it's only fair that we should look at the instances where it probably is not advisable to seek an award on a preliminary issue. And that, as a general principle, will be where there's no probability of saving time and expense by doing so. And if there is no such probability, then seeking an award on a preliminary issue will add to the time and expense of the case. So when might it not be such a good idea to go for a preliminary issue? One example would be where you're going to work on assumed facts rather than facts that are agreed between the parties. And the simple reason for that is that if you're working on assumed facts, the real facts may turn out to be different, which will render your award on the preliminary issue valueless. And similarly, in the question of facts, where your issue is closely tied in with other factual disputes, an award on a preliminary issue will not work because there's no one decisive knockout point. You may be expecting this to be my last slide, but it is not quite. I suggest that the potential for an award on a preliminary issue should be considered in every case. And this is now in a way enshrined in the LMAA procedures by the specific question that appears in the third schedule to the LMAA terms 2017. Question 6 is set out on the slide. But I also say, take care. Because an award on a preliminary issue is not always, as we may have seen, the silver bullet which will give you the magical solution to a complicated problem. And just as a reminder, to try and determine a preliminary issue where it is not appropriate to do so is to throw money down the drain. Now, in an earlier slide that I showed you, we saw that a preliminary issue is decided by a partial award under a special section of the Act. And the key word here is award. Because a partial award deciding a preliminary issue, like a final award, cannot be revised by the tribunal. Now, in other words, once the tribunal has issued a partial award on a preliminary issue, it cannot change its mind as regards that issue. It is true that the award may only be partial, but as to that part, it is final. And that means, as an award, that it is subject to challenge under the Act in exactly the same way as any other award. For example, for lack of jurisdiction, for a serious irregularity, or an appeal on a point of law. And that brings me rather inelegantly to the end of this short presentation. And thank you for your attention.
Thank you very much indeed, David, for your wonderful speech. And as you know, that we are all curious of the preliminary issues involved in the LMA arbitration proceedings. Now we are quite clear, and you have given us a clear definition and how to deal with that in a proper way. So thank you very much indeed. And if we have any questions, if the audience has any questions, then that will be put in the final Q&A session. So thank you. Then we are moving to the second speaker, as we have confronted with the IT technical problems. So the second speaker is now Nevil Phillips. Nevil is an outstanding barrister, and you all know that in UK, which Chinese people are not very familiar with, is we have two kinds of lawyers. One is lawyer, which is called solicitor, and the other is called the barrister. Then Nevil is a barrister, or we call him a counsel, a senior counsel, junior counsel as we may call him. Then Nevil will give us a presentation on how to submit the right documentation in the court proceedings, in the arbitration proceedings, in the proper form and the time, in a very good time, of course, as soon as possible in certain types of cases. So now let's welcome Nevil to give us the second speech. Nevil.
Thank you very much. Well, good afternoon, everybody. As David did a moment ago, I am going to try to share my screen with you, and I am hopeful that you will be able to see my slides. Can I have a thumbs up from someone to indicate that you can see them? I'm grateful, David. Thank you very much. So I am going to talk to you briefly about demurrage time bars and the role played in the way in which those operate by the need for supporting documents. And then we will also look briefly at some of the allied issues to which the need for supporting documents can give rise. Now, as many of you will perhaps understand, English law has long wedded itself to demurrage time bars, and it tends in general to respect demurrage time bar provisions. And the reason that it does so is because English law takes the view that time bars of this kind have a clear commercial purpose. And that purpose is something that was explained indeed back in 1982 by Mr. Justice Bingham in the Oltenia, and by Mr. Justice McNair in the Metalimex case. And I've set out on this slide two citations from those cases which describe in essence what English law sees as the commercial purpose. In essence, there are two purposes that English law gives high regard to. The first is that parties should be able to investigate claims and the factual basis for them while they are still fresh in everyone's mind. And the second is that the law also concludes that commercial parties are keen, where possible, to close their books and bring to an end the prospect of any dispute at the earliest available opportunity. And as we will see in a moment, these commercial purposes are a thread which is relevant to and which informs the role of the demurrage time bar in most of the cases that we now see in London arbitration. Now, pausing there, the question for all arbitral tribunals in England is, in essence, what is the nature of a demurrage time bar? And in almost every case, almost inevitably, that will be a question of contractual construction or interpretation. In other words, in giving effect or proper effect to the demurrage time bar, what the tribunal is concerned with is understanding and interpreting the words of the demurrage time bar provision within the charter party and then giving effect to those. And the English law approach to the construction of contracts is relatively well established, and indeed, as I've put on the slide here, it was summarized as recently as only 2 weeks ago by a specially constituted commercial court bench in an insurance dispute arising out of the recent COVID pandemic. And there the commercial court reiterated that for the purposes of determining what the words of a contract or a provision mean, a tribunal must firstly ascertain what a reasonable person, so a reasonable commercial person, that would have had available to them all of the knowledge available to the contracting parties, what that reasonable person would have understood the contracting parties to have meant by the language they used in the clause. That means that because it is an objective exercise, we put to one side the evidence of the subjective intentions or beliefs of the parties. And then we consider and we weigh up the commercial consequences of two possibly competing interpretations or constructions. but we cannot allow ourselves to use common sense as a bootstraps argument which almost reinvents the meaning of the contract by hindsight. And the golden rule, if there now is one, is that where the parties have used clear and unambiguous language, that is the meaning which one has to give to the contract. Now, bearing in mind those principles, we can then consider what the approach is when we look at demurrage time bar provisions, and we look at the need in particular for all supporting documentation to be provided with the demurrage claim. And that is a formulation that we see very, very frequently in demurrage time bar provisions. And it's a formulation which indeed was at the heart of the three cases which I'm going to touch upon with you today. The first was the Tiger Shanghai, and the issue there, as we will see in a moment, was whether a survey report, which one party alleged in any event was a privileged document, a document which didn't need to be provided to the other party, whether that was a supporting document in circumstances where the relevance of that survey report was in question. In the Amelie Esberger, the issue there was whether the time bar provision, which expressly referred to specific categories of documents, had the effect that those documents had to be provided, or whether it was only necessary to provide those documents where they were of proper relevance. And lastly, the MTM Hong Kong, where the issue was whether bills of lading, in the context of the specific demurrage time bar provision there in question, needed to be provided as supporting documents. Without wanting to spoil the plot, in each of those three cases, the court concluded that the document in question did indeed have to be provided. And the theme that emerges from each of these decisions, as we'll see, is that the term supporting, when it comes to the nature of a document, in the eyes of English law, is a wider term than simply a primary document. In other words, a document of central evidence which supports the claim, or simply a relevant document or a disclosable document. Disclosable meaning that if the matter went to arbitration, you would need to provide it by way of your normal standard disclosure to the other party. So in each case, the court said the document does have to be provided. It is a supporting document. And in each case, the court said supporting, the word supporting means something more than just primary or relevant or disclosable. So let's look at the first of those three cases, the Tiger Shanghai. Now, the Tiger Shanghai, it is fair to say, was not in fact a case specifically about demurrage, but it did encompass all of the principles which are familiar to us and which are relevant to questions of demurrage time bars. And the claim in that case was in fact a claim by the charterers under a charter party for damages for a repudiatory breach of the charter party. And as you'll see from the slide here, in essence, what had happened was that the charterers, pursuant, they said, to a provision within the charter party, had asked the owners for permission to cut additional cement holes in the vessel. The owners had refused that permission. The charterers said, well, that is a repudiatory breach, so we will terminate the charter party and bring a claim in arbitration for damages. And then in the subsequent arbitration, which in fact took place about a year or so later, the charterers appended to their claim submissions a survey report of the vessel, which dated back to the time of the breach. In effect, it was the report of a surveyor who had been sent to the vessel in order to determine whether the cement holes could be cut and where they might be cut. And that was prior to the owner's refusal to allow permission for the holes to be cut, so before the repudiatory breach exploded, as it were. And that survey report hadn't previously been disclosed to the vessel owners in any way, shape or form. So the first time that the owners became aware of the survey report was when it was appended to the claim submissions in the arbitration about a year later. Now, when that happened, when the claim submissions were served and the owners became aware of the existence of the survey report, their response was to contend that on the basis of the time bar provision in the contract, that charterers' claim for damages for repudiatory breach was time barred. And in so arguing, the owners said, well, if we look at the time bar provision, that requires the written notification of any claim which must be accompanied by all available supporting documents. And the owners contended that the survey report, as exhibited to the claim submissions, was a supporting document for the claim in question, therefore that the claim was time barred. And the charterer's response to that was to say, no, 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 that is not what the clause means. All available supporting documentation means only those documents which are reasonably necessary to explain the proposed claim. And indeed, it only encompasses documents which are unquestionably disclosable at an earlier point in time, prior, as it were, to the service of the claim submissions. And they argued, therefore, that the survey report was not an essential or necessary document to explain the claim. They said the survey report did no more than go to a potential dispute as to whether the owner's refusal to permit the cutting of the cement holes was reasonable. In other words, if the owners contended, or rather if the owners didn't take issue with the fact that the request to cut the cement holes was a reasonable one, then the survey report would be irrelevant and there would be no need to have regard to it. And therefore the charterers said, if that's the case, it isn't yet a relevant document until we have seen how the owners plead their case in defense, and therefore it's not a supporting document. Now, the owners, for the purposes of their argument, drew on the commercial purpose of time bars, which I touched upon a moment ago. And they said, the way in which this works is that in order for us to take an early view of the merits, and in order for us to be able to investigate the factual basis for any claim, and in order for both parties to have contractual and practical certainty at the earliest possible stage, we need to be able to see all available supporting documents so that there are no unpleasant surprises waiting for us further down the line. And using that commercial purpose, they said all supporting documents therefore includes that survey report, because that is precisely the kind of document we would need to see in order to be able to understand and investigate the claim. The commercial court agreed with the owners. So Mrs. Justice Cockrell held, as you can see from the slide here, that any relevance or disclosability test, so the looser sort of test that the charterers were contending for, was too vague. She said, as a matter of construction, the words all supporting did require the survey report to be provided, not least because if it was attached to the claim submission served by the charterers, that was strongly suggestive of the fact that it was a supporting document, because ordinarily one only provides with the claim submissions those documents which one believes to be supportive of the claim. She added that merely therefore because the document emerges, in other words, merely because the document is revealed to the other party later in events, does not mean that it wasn't a supporting document from the outset. The position would be different if the document didn't exist at an earlier stage in time, but that wasn't the case here. And as it was, the reasonableness of the owner's refusal to permit the cement holes to be cut in the vessel was, in essence, the very heart of the dispute. So the survey report was inevitably supportive of any claim in that regard. So standing back, Mrs. Justice Cockrell came to the conclusion that what is supportive in terms of documentation to be provided will be dictated by the nature and detail of the claim being advanced. And if there is a document which supports that claim, whatever its nature, then it needs to be supplied. And she said it was therefore telling and significant that in following that process, the charterers used that survey report in order to support their own case and in anticipation of what they thought the owners might say in their defense. And the obvious conclusion to draw, the court held, was that the document for those reasons was a supporting document. And it followed, therefore, that even what one might call extended primary documents, things like survey reports, can be within the scope of supporting documents, although what we might call conventional secondary documents, things like witness statements or expert reports, which are, as it were, confirmatory or corroborative evidence of other sources, might be less likely to be characterized as supporting documents in other cases. Now, what about the Amelie-Esberger? Well, that is a straightforward demurrage dispute, and that illustrates the same principle. Now, the time bar clause, which was addressed in that case, was a familiar one. It provided that any claim for demurrage, among other claims, should be considered waived unless a written claim was received by the charterers or their brokers in writing, with all supporting calculations and documents within 60 or 90 days. It was a confusing clause. And it provided also that demurrage, if any, must be submitted in a single claim and must be supported specifically by certain categories of documents. And there were, in fact, 4 of them, A to D. And it was categories C and D, which were in issue in that case. Now, what happened was the owners provided a demurrage claim within the relevant timescale, but they neglected to include with their demurrage claim 2 of those 4 categories of documents, C and D, the pumping logs from the load port and a letter of protest from the load port. But the reality was that, in fact, those documents had been provided by the owners to the charterers at an earlier stage, because they'd been given to the owners, I beg your pardon, to the charterers, upon completion of loading as part of the general package of documents which the owners were in the habit of providing to their charterers at the completion of the loading stage. So although the documents weren't submitted formally together with the demurrage claim, the reality was that the charterers did already have those 2 categories of documents in their possession because they were given to them as part of the completion of loading document package. So the charterers contended that in those circumstances, the failure to provide those 2 categories of documents at the time of submitting the demurrage claim was fatal, and that it triggered the time bar. The owners, in contrast, said, well, that's not right. Supporting documents relates to key or core elements of the demurrage claim. And they said, so bearing in mind that test, those 2 categories of documents, C and D, only have to be submitted with the demurrage claim if they are relevant to the internal elements of the demurrage claim. And they said they weren't relevant to the internal elements of the demurrage claim. Pumping logs and letter of protest at the load port had nothing to do with the issues on which the demurrage claim itself would turn. Therefore, they were not relevant. Therefore, they didn't need to be provided as supporting documents. And the owners also contended that in any event, there was a de minimis implied exception to be applied to the time bar. In other words, if irrelevant documents are not provided, they should not trigger the time bar, because if you apply a de minimis exception, things which are trivial or not directly relevant don't in fact need to be supplied, regardless of what the contract says. Now, the Charterers, in response to that, said that's not correct. All supporting documents means what it says. It doesn't include any test of relevance, and it certainly doesn't suffice to produce documents which are directly relevant. All supporting documents means all supporting documents, relevant or not. And they added that, moreover, where a time bar provision such as the one that we saw a moment ago in fact stipulates expressly for specific documents, A, B, C, and D, those have to be provided regardless of whether they are relevant or not. If the clause tells you, among other things, you must support your application for demurrage, your claim for demurrage, with these 4 categories of documents, you have to include them, whether they are relevant to the claim or not. And they therefore characterize those documents as documents which are deemed to be supporting, even if for practical purposes they are not. And the answer the court held was that the Charterers were correct. The owners were required to submit documents on which they relied in support of their demurrage claim, whether relevant or not, and any documents which at face value established the validity of the demurrage claim were therefore to be provided. And moreover, where the relevant time bar clause expressly stipulates that certain documents must be provided with the claim, that is invariable. You must comply with it. Those documents must be submitted with the claim, and therefore a failure to submit them, even if they are wholly irrelevant to the actual issues in the demurrage dispute, gives risk to a time bar. So what about the third of those cases, the MTM Hong Kong? Now, that again was a claim for demurrage, focusing this time on the discharge port. And the facts here were that there were 2 parcels of cargo discharged at the same berth, and that was in circumstances where the charter party provided that where you had simultaneous discharge at the same time, lay time was prorated between the 2 cargo parcels. And any delay or waiting time or lay time or demurrage was therefore allocated pro rata according to bill of lading quantities. So the owners submitted, again, a demurrage claim within time, and that was supported by the demurrage invoice, their lay time and demurrage calculations, notice of readiness, a statement of facts, pressure logs, and letters of protest. But the things that were missing from the package of documents presented with the claim were the bills of lading. And the Charterers therefore contended that in those circumstances, the time bar had effect and the demurrage claim was time barred. The owners said, well, that's not correct. Our claim is sufficiently documented because the statements of fact tell you what the bill of lading quantities were. And in any event, the bill of lading for the second parcel, insofar as concerned a claim for demurrage against the parties in relation to the first parcel, was not an available supporting document because it was a confidential contract with a third party, and therefore it ought not to be disclosed in any event. So they said the supporting documents, in inverted commas, require only the provision of documents that are relied on by the owners in the relevant claim and which are sufficient to allow the Charterers to understand and evaluate that claim. So in essence, we see again an argument from the owners that supporting documents, in inverted commas, doesn't mean supporting documents. It means only necessary or relevant or essential or key or disclosable. It's some lesser standard. And the owners said, well, if you've got the statements of fact which contain the bill of lading quantities, you don't need to see the bills of lading themselves, and therefore our claim is not time barred. And the judge, Mr. Justice Robin Knowles, disagreed. He said that the claim was time barred. And the reason for that was, he said, you cannot treat the bills of lading as being outside the requirements of the time bar. There is no evidence that the bills, in fact, were unavailable to the owners. And even if the bills were not available, in any event, what would need to be submitted at the same time as the demurrage claim is a proper explanation of that fact. In other words, if a document which would expect to be included as a supporting document is not in fact available, then at the time of making your claim, you need to include an explanation of why it's not. And that's quite an important aside or caveat to remember. And they said, the court said, even if the bills were treated as confidential, that should not prevent the need to supply those documents as supporting documents, because any sensitive information in the bills of lading can be redacted, it can be blocked out, but you can still give the document to demonstrate the quantities of cargo discharged. And therefore, the court concluded that the claim for demurrage was indeed time barred, because as a matter of contractual construction or interpretation, the time bar clause required the bills to be provided as supporting documents, because they would enable the tribunal and indeed the charterers to establish what the prorating was for the purposes of the demurrage claim. There was nothing, the court said, in the owner's argument that signed statements of fact are essential or primary documents, and that bills of lading are in some secondary category. And the fact that the statement of facts therefore contained the same information as to cargo quantity as would appear from the bills of lading did not stop the bills of lading from being supporting documents. Now, having addressed those three cases, we can see that each one gives us a fairly clear illustration of how English courts and arbitral tribunals approach the scope of supporting documents. And generally speaking, if there is a lesson to draw from those cases, it is when advising an owner to submit documentations with a demurrage claim, err on the side of caution and provide to the charterers within time anything and everything that might conceivably be relevant to the demurrage claim. Likewise, if you're advising a charterer, look for any obvious omission from the documents that have been provided in order to determine whether that affords you a defense of the time bar. Now, one further issue that arose in the Tiger Shanghai was what happens when one of the so-called supporting documents might in fact be privileged. In other words, if you have a document which would otherwise be a supporting document, but it might in fact be privileged from disclosure because it's a lawyer-to-lawyer communication, or because it attracts some other species of legal privilege which protects it from being shown to the other side, does that mean that for the purposes of a demurrage time bar provision, you don't in fact have to supply that document with your demurrage claim? And the answer to that question from the Tiger Shanghai is no. Even documents which are arguably privileged have to be disclosed and supplied at the time of making the demurrage claim. And therefore what we saw in the Tiger Shanghai, and you'll remember this was the case about the survey report, was it was argued by the claimants in that case, the charterers, well, we don't need to provide the survey report because it's a privileged document. It was procured and prepared in contemplation of litigation. Privileged documents of that kind don't need to be disclosed in arbitration. Therefore, the same principle must follow for the purposes of the time bar. And the court held that that was not correct. The court described that stance as profoundly uncommercial and said that it would sit very ill with the purpose of certainty which underpins time bar clauses. If time bars have the purpose of enabling the parties to know as soon as possible where they stand, it would make no sense that you could sit on a document because you had an arguable claim that it was privileged. And the court concluded, therefore, that while it might be that the proper place or the proper forum for resolving any question of privilege was in arbitration. That was a debate which had to be taken after the event. And in effect, in practice, it will mean that that debate doesn't happen because a privileged or an arguably privileged document has to be supplied at the same time as making the demurrage claim. And then the last principal issue which arises in the context of demurrage time bars is the timing of the provision of documents. When, for the purposes of a demurrage claim, do the documents have to be provided? Does it matter if they are not provided with the package of documents that accompanies the written demurrage claim, but are provided later, but still within the period of the demurrage time bar? Indeed, is it permissible, looking backwards, to provide those documents at an earlier stage? And in the Amelie Esberger, the charterers, you may recall, relied upon the fact that the demurrage clause there provided that the claim for demurrage must be received with the supporting documents, and that the demurrage, in inverted commas, must be submitted in a single claim. And they said, well, giving all of those words their ordinary and natural meaning, that means that you only have one shot at putting the documents in before the charterers. You have to do it at the same time as you submit your demurrage claim. It has to be done as one package in one go at one time, all within the time bar period. And the owners said, well, that's not correct. The way in which, in fact, you should approach this is to say, provided that we give you the documents within the time bar, it doesn't matter if we do it in stages. We give you the demurrage time bar claim, and then a week or 2 weeks later, we give you some further supporting documents, all within the 90-day period. And indeed, it would be sufficient if, remember the facts in the Amelie Esberger, if we had already given you those documents, because in fact you had had them as part of the package of documents that we gave you at the completion of loading. And the court in the Amelie Esberger agreed with that approach from the owners. The court said, when approaching this, it's not necessary that the documents have to be given in one go with the package of documents that accompanies the demurrage claim itself. When the contract and when the provision describes the documents as having to be presented with the demurrage claim, that simply means in time. And the reference to the need for a single claim for demurrage referred simply to the fact of the demurrage claim. It didn't mean that you needed to actually sweep the documents together physically with the demurrage claim itself, and that everything had to be presented in a single package at a single moment. So there is a greater element of flexibility, perhaps, in the timing of the provision of documents. And in the Amelie Esberger, it was observed that this was consistent with the earlier decision of the Court of Appeal in the Abcake. And then one last issue to bear in mind: what happens in circumstances where the documents which are omitted from the presentation of a demurrage claim, in fact...
Sorry, Nevil, time is up. Can you finish within 3 minutes time?
This is my last slide.
Okay.
So what happens when the documents that are missing are documents which affect only a part of the demurrage claim, but not the whole claim? And the answer to that is it will depend specifically on the wording of the clause. But so where, for example, you have a clause that refers to constituent parts of a claim for demurrage, and there is earlier authority for this, that will mean that the failure to provide documents will affect only the relevant part of the demurrage claim. The rest of it will not be time barred. But in cases where you don't have a reference to constituent parts, but instead a reference to a single claim for demurrage, and the Amelie Esberger and the MTM Hong Kong are examples of that, a failure to provide a supporting document will bar the whole demurrage claim. So that underlines the importance of ensuring that when you're checking for supporting documents, you err on the side of caution and put everything in. So thank you very much indeed. I'm conscious that I've used up my time, but I'm very grateful to you for your patience in listening to me. And that is all from me.
Thank you, Nevil. Sorry for interruption. Time is up, so I have to stop you. As I've introduced you to all the audience, Nevil is a senior barrister or counsel. They call themselves senior junior in Quadrant Chambers, which is one of the leading chambers firm of counsels, barristers based in London. And his intro, as well as the intro of David Martin Clark, are all in the third bundle we have distributed to all the audience prior to today's webinar. Then lastly, we welcome Mr. Ian Gaunt, the former president of LMAA. Ian needs little introduction. Ian is supposed to be the first speaker and the moderator, but due to the technical problem, he has logged in a bit later. So now Ian is the last speaker, and Ian will also make a closing speech after his presentation as the end of this three webinar series. Ian.
Thank you, John, and good morning or good evening, ladies and gentlemen. I'm sorry that we have had to change the order of our presentation somewhat this morning, and also that some of you have had difficulties in logging on. Unfortunately, the software was changed at the very last minute after we had done our practice run for this seminar, which caused a little confusion at the beginning. I'm also blessed today with a slightly unstable internet connection, but I hope that you will be able to hear me continuously. If you are not, then I would refer you to the slides that I produced and the links in the slides where you'll find further information about what I want to present on. I'd like to thank Nevil, Phillips, and indeed David Martin Clark for their excellent presentations on rather different aspects of the law and procedure, but nevertheless very relevant ones if you are arbitrating in London arbitration proceedings today. Nevil has brought you completely up to date with the very complex law of demurrage, and David has been able to emphasize the importance of being able to isolate preliminary issues as a means of trying to shorten proceedings and save costs. I'm going to talk about something which has really only come up in the last year as a result of the COVID pandemic, and that is the way in which arbitration hearings in London and internationally are now increasingly being heard online. And of course, one of the things I'm going to emphasize as being particularly important if you're going to go down this route is to have a very stable internet connection, which is unfortunately not what I may end up having today. If you don't have a stable internet connection and you're going to be in an arbitration all day, then normally you will line up a second fallback position, another link, but there may not be time to do that today if we do experience problems, for which I would apologize in advance. You're all, of course, aware of what happened with the pandemic, which for many people came pretty much out of the blue, and where we had to work very pragmatically and very quickly in order to find a way around the problems which were arising in connection with the holding of arbitration hearings. The LMAA, and the LMAA is a very pragmatic body because it conducts ad hoc arbitrations. It can do things very quickly, unlike some of the more heavy-handed arbitration institutions. We can change our rules and our working practices quickly in order to suit the circumstances. The first thing that happened when the pandemic hit was that many people who had arbitration hearings set up in London wanted to adjourn them, and they said, well, we can't possibly hold effective arbitration hearings in the current circumstances where we can't have everybody physically present in the same room. And we already had a good deal of experience of hearing evidence from witnesses, particularly online by video conference. And the facilities for this had improved enormously over recent years. The quality of internet connections, as we generally experience today, is now good, and we can rely on them for a continuous hearing. So the LMAA decided that it would set up a working group to study IT in relation to the holding of arbitration hearings and arbitration more generally. And I'm the chairman of that group. And we set up ourselves a mandate, which you can, I think, see on the screen, or if I can have the first slide. I'm not sure whether it's up on the screen at the moment. Can you put the slide up, please? Well, in the absence of the, that's demurrage. Right, here we are. Right, could you move on to the next slide, please? Well, in anticipation of that, I can say that the mandate of the working group was to study the arrangements for the conduct of virtual hearings, and further, in due course, to develop proposals for the further use of information technology in the conduct of London maritime arbitration. But our first priority was to deal with virtual hearings. Can I have the next slide, please? So as a result of our deliberations, and we took on board input from people who were actually involved in the industry, from solicitors, from barristers, from people at the International Dispute Resolution Centre who were responsible for hosting many of these hearings. And as a result, we drew up a series of guidelines for the conduct of virtual and semi-virtual hearings. And you can access those if you go onto the link which was on the screen a moment ago. And you'll be able to find out what we recommend. And we divide this really into a number of different sections. First of all, in relation to, if perhaps you could go back a slide, please, in relation to pre-hearing things which have got to be considered. And one of the major ones is to the bundling of documents for the hearing, because this is something where lawyers are going to be very intensively involved. If you've been involved in a London arbitration hearing, you will know that we normally rely on hard copy bundles, but in virtual hearings, we will rely normally on an electronic bundle. So all this documentation has got to be put into an electronic bundle, which can be accessed by all the parties during the hearing, and that requires a lot of work. So we've provided guidelines as to how that is to be done. A second point is, of course, as I've mentioned, that the IT connection has to be, so I'm not there yet, please. Could you go back 2 slides? And the quality of the IT connection is, of course, very important. At the hearing, we have dealt with issues of etiquette, like how are the witnesses to be positioned in a room, how are we to make sure that they are not being prompted by someone in the room, how can we ensure that the witness in the room is alone. So these are all very practical considerations which we have had to take into account. And again, if you look at these guidelines, you will find a lot of practical advice as to how these hearings should be conducted. Is that we now find that there are quite sufficient facilities available to conduct virtual hearings online, and parties who come to a tribunal and ask for a hearing to be postponed will normally not be given much time. We will normally expect them to make arrangements for a hearing to be held virtually. And unless there are very compelling reasons for the hearing to be adjourned, very often for an indefinite period, because we don't know when this emergency situation is going to end, we will not allow an adjournment. The platforms that we use most frequently, some of these may not be available in China, but Microsoft Teams is one of the facilities which is used also by the courts. Zoom is probably the most widely used and has been found to be the most effective, particularly now that Zoom has changed its software to make it more confidential. There is also a facility called Blue Jeans, which has been proved to be very good, and Cisco WebEx, and all of these have their own minor advantages and disadvantages, but essentially all of them can be used for the purposes of conducting a virtual hearing. Could I have the next slide, please? Thank you. I've already touched on some of these issues which have to be particularly considered. The first one is, of course, disclosure. How are you going to deal with disclosure, which normally involves the exchange of a lot of physical documents? Well, you may well be able to set up a separate platform for the purposes of sharing the documents during the disclosure process, and this can be very efficient. In anticipation of the hearing, you need to give a lot of consideration and attention to the bundling of documents and to considering with the other party how documents are going to be managed and how the hearing is going to be conducted. And the tribunal will have some say in that, but essentially this is a matter for the parties to arrange. And very often they will want to bring in a third party to manage the hearing so that the tribunal themselves are not burdened with the actual conduct of dealing with the IT issues which may arise during the hearing. The quality of connection and backup are very important, and I mentioned that we need to make sure that witnesses are not prompted. Can we move to the next slide, please? The result is that we now have, since March of this year, a lot of experience of hearings being held, first of all, semi-virtually. By that I mean that the evidence of some of the witnesses is taken online, or completely virtually, where everybody involved is in a separate location, as we have had with this webinar today. And speaking personally, I can say that I've now experienced of 3 hearings which have been held completely virtually, 2 as a sole arbitrator and 1 as a panel of 3, and all of them have worked extremely well. So we think that this is a satisfactory system, that the parties are not disadvantaged, that cross-examination of witnesses can be perfectly satisfactorily conducted by means of online hearings. Could we have the next slide, please? And it has its advantages, and we think that these advantages will prove themselves long-term, even after we strictly have no need for virtual hearings. We have a lot of experience dealing with arbitrations concerning Chinese parties in London, where many witnesses have had to travel extremely long distances, halfway across the world, in order to give, say, 15 or 30 minutes of live evidence in London. Well, this seems to be, in most cases, completely unnecessary. And it has been shown that these witnesses can be satisfactorily cross-examined online, and that it is unnecessary for them to travel to London in order to give their evidence. And we think that that will, in many cases, continue after the lockdown and after it's possible again to resume physical hearings. So this is an advantage which will come out of this crisis situation. And in due course, too, there should be less need for physical documents to be used in the course of an arbitration hearing. For those of you who've been to arbitration hearings, you will know that every party has to have access to a set of the arbitration documents, and usually, traditionally, in hard copy form. This is enormously wasteful. And in these days when we are increasingly emphasizing the sustainability, we want to move towards electronic documents, which can nevertheless be handled in a very similar way to the way we have been used to handling hard copy documents. And we found that should now be possible. So these are both long-term advantages which we think will flow from the conduct of virtual hearings as they're now being held. Now I move to the next slide, please. Well, in the context of sustainability, you might like to have a look on this link, which is a campaign which is being waged by an arbitrator called Lucy Greenwood, who has set up a website called greenwoodarbitration.com. The name is rather good for environmentally friendly purposes, Greenwood. And she's formed something called the Green Pledge, where those who sign up to the pledge are committed to trying to conduct arbitrations in a more sustainable manner. And this particularly means the use of less hard copy documentation. So I would recommend that you have a look at Lucy Greenwood's Green Pledge. I'd also suggest that if you're interested in what is happening in the world of virtual arbitration, that you have a look at another website which has been set up to try to collate and bring together information from a variety of sources about how arbitrations are being held virtually, and different tips which can be used from the experience of people who have been involved in virtual arbitrations. So that's https://virtualarbitration.info. And can I have the next and I think last slide, please? What have we now come to? I think the end of what I wanted to say. So that is really an update on where we are on virtual hearings. I know that virtual hearings are also being held in courts and in arbitrations in China. Last week I was given access to a WeChat article on the conduct of a virtual court hearing in the Shanghai Maritime Court, where the facilities look to be extremely sophisticated, and where evidence was being taken from an expert witness in London by video, and where also we understand that the court was relying on machine-based translation facilities, not exclusively perhaps. So this is another area where IT may become important in the conduct of arbitrations. So our working group will keep under review the facilities which are available for virtual hearings, for virtual disclosure, for the conduct of arbitrations on electronic platforms, and we will, as necessary, adapt our rules in order to make sure that we remain at the forefront of this technology. What about enforcement? Well, is there a problem with enforcement of awards which are produced as a result of virtual hearings? Well, we don't think so. It's quite clear under the English Arbitration Act, and bear in mind that all, or almost all, LMAA hearings are seated for jurisdictional purposes in London, and therefore English law will apply. Under the English Arbitration Act, Section 33, the obligation of the tribunal is to give the parties a reasonable opportunity for their case to be heard. And from our experience so far, we are satisfied that if proper arrangements are put in place, virtual hearings will enable parties to have a reasonable hearing. So that if it comes to the enforcement of an award in China, which has been issued and published after a virtual hearing, we are pretty satisfied that the Chinese court will refer the question of the conduct of the proceedings back to English law, and that the virtual hearing will be treated as being a perfectly valid hearing and the award as a perfectly valid award. So that's where we stand at the moment, and I'd like to bring this presentation to a close, and also in closing, to again thank my co-speakers, Nevil Phillips and David Martin Clark, for their involvement, and indeed all the speakers who've taken part in the 2 previous webinars which we have held as part of this series. It's been a privilege for us to be involved and to be able to help to clarify various aspects of English maritime law and English arbitration practice. And we hope very much that what we've been able to put across in these seminars is of use to you in your studies. And for those of you who are listening to this webinar from outside China, that it again helps to bring you up to date with what the LMAA is doing and London maritime arbitration practice. I'd also like to thank the organizers of the seminar, Shanghai Maritime University and John Lin in particular, for the effort which has been put into this, and once again apologize for the difficulties we had in getting online this morning. I think it remains for me to wish you a happy Moon Festival, and I'm sure that many of you are going to be now rushing off to your families to celebrate. So thank you all very, very much, and I'll hand over to John to close the proceedings.
Thank you very much indeed, Ian, and also thank you very much indeed to all the speakers today and in the past 3 webinars. And now we are closing this year's SMU and LMA event. And this year, LMA is celebrating the 60th anniversary of this wonderful arbitration organization in this planet. So we wish LMA will have another 60 years prosperous experience in the future. 再次的话呢，我们要向各位听众呢就是抱歉，就是今天的话呢有一些技术问题，导致呢刚开始的时候呢大家入场的不畅，而且呢还是有很多人最终呢是没有入场，我们非常抱歉。今后的话我们一定会注意努力的改进我们网络会议的进程和入口。另外的话呢，就是也接着Ian Gaunt 先生他刚刚就是给各位的那个祝福。我们的会议组成员在此的话呢，也祝各位就是中秋节快乐并且呢就是国庆节快乐长假快乐。今年年底明年年初我们还有进一步的活动希望大家能够参加。这3个礼拜的 webinars 的录像我们呢会在节后有通知，就是会在什么样的网站、什么样的那个接口。大家可以进行那个浏览。最后呢，再次感谢大家参与我们今年的活动，感谢。我们等最后。Hi, Nevil.
Hi.
Hi, we're closed. The meeting is off. So thank you very much indeed.
That's fine. Thanks very much.
And
thanks.
I wish you will be a QC in the shortest time.
I need to make the application.
Yeah, well, I have cases, arbitration or high court cases from time to time, and to be honest, we use four-part court and other chambers. So next time, if I have a single case, then I will come up to your chamber to you.
That I would be very grateful and very honoured. I'll do anything to take the work from four-part court.
You are very senior, I think.
I am, yes, I mean, I should have applied to become a QC some time ago, but I have been so busy and I think enjoying myself too much. So I've not yet made the application, and I keep intending to do so, but I need to get around to it.
Best luck. Best luck. I think that you need to do more high court cases to be qualified to make the application. Is that right?
Not necessarily. Arbitration is sufficient. It's the main impediment is that it is you need to complete a 70-page form, which is evidence-based, and you need to have 12 arbitral or judicial referees,
yes,
and 12 personal referees. It's a very arduous process, and if you're a busy practitioner, it's actually quite difficult. Absolutely.
Money is important. Fame is another.
Quite so, and I've been earning enough money as a senior junior that I haven't felt yet the need to apply, but at some point I shall.
Yeah, I recall 2 years ago, I wrote a referee letter for Alex Wright. Do you know Alex Wright of four-part court?
Alex Wright, yes.
But I don't know the result, whether he has been elected as QC or not.
No, he hasn't yet. No, he hasn't yet. It will come. He's very able. It will come. But yeah. So, well, if you send me some instructions on a great big case, I will come to you as my referee, John.
my pleasure and honor.
Well, I look forward to that. But yes, it would be a privilege to work with you. I would like that very much.
Okay, thank you very much indeed. Bye for now.
Thank you for including me, and have a wonderful holiday.
Bye-bye.
Bye-bye.
另外两个